From the beginning of the Constitutional Convention, the existence and scope of federal judicial power was deeply contested. There was general agreement on the need for one national tribunal, the Supreme Court of the United States, to exercise the judicial power of the new nation. However, the existence of lower federal courts and their jurisdiction met deeply entrenched opposition. Some considered these courts expensive redundancies, since state trial courts could be available to hear constitutional and federal questions. Others saw potential for encroachment on state sovereignty and jurisdiction. Some of the delegates to this convention were determined to have no federal courts. Others thought perhaps only those capable of hearing claims in admiralty. Other delegates were determined to mandate the existence of lower federal courts. James Madison and James Wilson crafted the famous Madisonian Compromise, which gave Congress the option to create the lower federal courts but did not mandate their existence. This compromise was accepted, and the language of Article 3, Section 1 of the Constitution was ratified. Thus, this article provides the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as Congress may from time to time ordain and establish. Article 3, Section 2 goes on to describe the Supreme Court's original and appellate jurisdiction and provide that Congress shall have the power to make exceptions and regulations to the appellate jurisdiction of the Supreme Court. Now, what should we take from this constitutional text? If Congress has the power to decide if the lower federal courts even exist, does that follow that Congress has plenary or sweeping power to modify the scope of their jurisdiction? Does the power to make exceptions to the Supreme Court's appellate jurisdiction mean that Congress can prevent entire classes of controversial subjects from even reaching the Supreme Court? Could Congress, for example, prevent the lower courts from hearing challenges to state laws regulating abortion, to claims challenging the constitutionality of the Pledge of Allegiance, prayer in schools, petitions brought by the prisoners held at Guantanamo Bay, same-sex marriage, challenges to the Ten Commandments? Are these laws proper as exceptions and regulations to the lower court's jurisdictions, or are they actually aimed at securing the effect of a constitutional amendment through the passage of ordinary legislation? Many of these laws, if enacted, would free the state courts from judicial oversight, would liberate them to develop their own constitutional doctrines. Is this contrary to Martin v. Hunter's lessee, which asserted the Supreme Court's power to review final decisions of the state courts on federal questions? Congress has considered and occasionally acted upon proposals like these. In this chapter, we will consider the scope of Congress's power to regulate the jurisdiction of the federal courts. The leading case on this subject is the 1850 decision of Sheldon v. Sill. Two Michigan residents entered into a promissory note and took a mortgage in return. One Michigan party to the transaction assigned his mortgage interest to a New York resident, who then sued in federal court invoking diversity jurisdiction. However, the parties had a conflict with the federal statute, the Judiciary Act of 1789, which prohibited diversity jurisdiction from being created by the assignment of a debt. The act provided that cases could only be heard in the federal courts if they would have had jurisdiction to hear them prior to the assignment of the debt. The question in the case was whether that statute conflicted with the terms of Article 3, which flatly authorized the federal courts to hear diversity cases with no such limits on jurisdiction arising out of an assignment. The Supreme Court upheld the statute, relied on the exceptions clause, and said very broadly that as creatures of statute, the lower courts can have no jurisdiction but such as the statute confers, thus affirming the power of Congress to make exceptions and impose limitations on federal jurisdiction. Now, at some level, this is uncontroversial. Few would contend that Congress lacks power to set amount and controversy restrictions on diversity cases, despite the fact that such a limitation keeps otherwise diverse plaintiffs from bringing their claims to federal court, and thus limits the scope of federal jurisdiction below the constitutional maximum. The question is, how can we distinguish Congress's power to make exceptions and regulations of this sort from jurisdiction stripping statutes that distort and modify substantive constitutional rights? Four competing theories have emerged to divide and assess the scope of Congress's power in this area. The first was developed by Justice Story and furthered by Akhil Amar. In this theory, since the language of Article 3 provides that the federal judicial power shall be vested, the argument goes that Congress is obliged to vest the entire judicial power in some court, and once it creates the lower federal courts, may not diminish their jurisdiction below the constitutional maximum. This is the most radical and expansive vision of federal judicial power. It is accepted by the fewest number of scholars. Its fighting history, given that the federal courts did not receive federal question jurisdiction by statute until 1875, it would call into question the amount and controversy statutes and many other laws. On the other end of the continuum, there is the broadest reading of Sheldon versus Sill. This is actually the orthodox view held by the widest number of constitutional scholars and federal courts, federal judges. Under this approach, Congress simply has plenary power, both to create and to modify the jurisdiction of the federal courts. The argument is the greater power to create them in the first place includes the lesser. If there was no obligation to create, there could be no constraint on the power to limit federal jurisdiction. Now, the difficulty here, of course, is that this orthodox approach would legitimate any jurisdiction-stripping statute Congress enacted, which is troubling, relies on the constraints of the political process to protect the federal courts from limits on subject matter jurisdiction. What middle ground is possible between these two extremes? Larry Sager has developed one theory, arguing that federal courts must be available to rule on some issues. His argument goes that if state courts cannot hear a claim, and if the Supreme Court lacks original jurisdiction, then there will be no vehicle capable of exercising the federal judicial power unless some federal court is available. Examples of cases where the state courts would lack jurisdiction include writs of habeas corpus to federal prisoners and writs of mandamus to federal officers. State courts can never hear such claims. Under Sager's view, some federal court therefore must be available to hear them. Also, he contends that Congress may not selectively limit the jurisdiction of the lower federal courts, or of SCOTUS, to specific substantive issues or substantive category of cases. He rejects such laws on the ground that they invite state and federal officials to engage in conduct that the Supreme Court has ruled unconstitutional, or to insulate their own unconstitutional conduct. He also relies on the salary and tenure protections given to federal judges in Article 3, Section 1. The bottom line of Sager's theory is that Congress is obliged to vest the whole federal judicial power somewhere, but that it need not be in the lower federal courts where state courts are available and where the U.S. Supreme Court has the ability to use its appellate jurisdiction to review those decisions. A different middle ground, defended by Lawrence Tribe and others, contends that while Congress can choose to create the federal courts and can tinker with their jurisdiction, it cannot do so in ways that violate other constitutional provisions. For example, it cannot modify their jurisdiction in ways that would deprive litigants of due process of law, or violate the suspension clause. It could not pass a law that would deprive any federal court of jurisdiction to hear a constitutional claim. Here one can invoke structural arguments like separation of powers, as well as specific constitutional provisions, to limit Congress's power. As you read the next set of cases, ask yourself whether the Constitution gives us a right to a federal tribunal to hear federal claims. Should it? Does it make a difference if the claim is a constitutional challenge to a federal law? And what power does Congress have over the jurisdiction of state courts? What help do the cases give us in answering these questions? We will discuss this as we work through our next set of materials.